The 10th principle is select multiple sources of clinical and behavioral information using relevance and reliability as guides. So keep in mind, it's not a fishing expedition. You don't just give them every possible instrument that might reveal some kind of problem. Be very, very careful about using instruments that are comparing it to applicant norms. I use Mike Roberts' PAI and CPI, but I use a different PAI report for fitness for duty evaluations. I do because these are compared to incumbent and applicant norms. Neither one is appropriate for a fitness for duty evaluation. These incumbent norms don't include necessarily the fitness for duty slice. So the norms aren't going to be appropriate. What we're going to be doing is this person's going to look really bad compared to the broad incumbent or applicants. So I think that it's important to use appropriate norms for these purposes, but remember its examination is narrowly tailored. So use assessment instruments that are appropriate for the referral question. Be wary of the agency that's cherry picking, and be wary of your own cherry picking. Rand, did you have a?
Oh, are there norms for fitness for duty?
There are no norms for fitness for duty evaluation. That's why I would use the community norms, focusing in on how they compare to the general population for purposes of diagnosis.
We'll wait for your next conference where you'll have the norms.
Man, I tell you, I would love to have them. Yeah, yeah. I'll work with Mike to develop them. So be wary of cherry picking. You want to see a full and complete historical record. And if you're aware as you're looking through records that, oh, there's something missing here, or you talk to the employee and said, by the way, did you see the report or did you see the conclusion, blah, 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 blah? And you're going, no, I didn't see that. I'm not surprised. Well, you might want to ask about that one. All right, I shall. And then you ask for it, and they go, "Oh yeah, well, didn't we include that?" No, you didn't include that. Oh yeah, well we'll send that right over. Okay, that happens a lot. So don't permit cherry picking, and don't you engage in cherry picking. The cherry picking can occur when you go through a computerized test result, and you pull out and highlight all of the really negative statements, and you ignore all the really positive statements. Well, of course, you're doing a fitness for duty evaluation. The negative ones are the ones that are most relevant to the question of whether or not the person might be unable to safely and effectively perform the duties. But if you're going to provide a balanced report, you don't want to just pull out those because it's going to impugn your objectivity and impartiality to a jury. So cherry picking is important to avoid.
In your chapter, do you specifically say community norms?
I don't recall whether I talk about that or not. I don't know. Probably not.
Okay.
Now, sources with little or no accuracy cannot increase the overall accuracy of the evaluation. Make sense? But it can decrease it if you give it much weight. So just because it's written doesn't mean it's true. And you must look at the whole picture, not just slices of it. And third-party information, in my view, and that includes treatment records, is really vital. So let's talk for a moment about, we'll come to this, treatment records. But before we do, we'll go through it. So you want to review the collateral records and information sources from both the employer and the employee. I ask the employee if there's any particular information, sources of information they think might be appropriate, that they think they would like for me to have access to. I want to hear their perspective. I already told you how I make an effort to form an alliance with the employee where they're working with me to make an accurate judgment. I want them to know that it is possible that I can make an error. And I want to avoid that error. That error is both in their interest to avoid as well as mine. It's in the interest of the agency, it's in the interest of the public. All parties want to avoid that error of finding them fit for duty when they're unfit. Or even fit for duty, or excuse me, unfit for duty when they're fit. So in doing so, I asked them if there are information sources, if there are records that they think might be important.
And this is included in your consent so that you can have them prior to the actual assessment date?
Say that again?
And this is included in your consent form sent to them prior?
No, it's not included in my consent form.
But they can send it afterwards.
No, no. So the third-party information includes personnel records in the medical file, because they're, as you know, under the ADA, they're separated. There's a medical file and there's a personnel file. Any IA or review board records, prior psychological evaluation if it's available, barring, of course, any particular disclosure that might have made that inappropriate. The availability of relevant healthcare records, narrowly defined, and I'll talk about that in a moment, and the position description. Now you go, well, do I really need a position description for a police officer, or deputy sheriff, or a correctional officer? You know, I've been doing this for 25 years. Yes, because the ADA requires you to have reviewed the position description relative to that position. So you want to make sure that you always get it as part of the record. Now, if you already have it for that agency, you don't necessarily have to get it each time you do one for that agency. Christina?
You have prior psychological evaluation and healthcare records separate from medical file. Wouldn't they be in the medical file? I mean, is that something you have to specifically designate?
No, but there might be a prior psychological evaluation that the employee wants to provide from another psychologist or neuropsychologist that the employer doesn't have. It's not necessarily from the employer.
Oh, sorry.
That's all right. And then collateral interviews, sometimes with coworkers, supervisors, family members, or treatment providers. Now, I don't call family members when the police officer, unless the police officer wants me to. I'm not going to just start, you know, drunk dialing. You know? I'm not going to do that. That's really invasive and can create real problems. Hi, this is Dr. Corey. I'm doing a psychological evaluation of your father. Just thought I'd check in.
And is your mommy home?
Yeah. Yeah.
And who's your dad?
Yeah.
Anyone else
Well,
around the house?
when you're done with your homework, would you have your mommy call? Yeah, no. Okay. So when you're reviewing these collateral records, it's yeah, when you're reviewing these collateral records, I guess I skipped ahead too fast. You want to ask, what is the objective evidence of impairment or direct threat? That's it. You're going to use these sources to help confirm what the employer has told you in the pre-referral conference, and it's going to help you form the scope. You know, when does the behavior occur? Under what context does it occur, or did it occur? Is it a commonly repeated behavior? Did it occur one time? Is it a change in behavior, or is this something that has been characteristic of the person across many, many years? You need to understand this behavior, and you can't do that without collateral data. What is the contradictory evidence that this is a one-time incident resulting from what we sometimes call the index offense versus a pattern of behavior over time? So you reach conclusions, and then you ask, what's the contradictory evidence? So, and you're usually going to have both. And then you have to weigh which evidence supports your position, supports which position most heavily. And what has been the behavior pattern over time, of course, is always crucial in understanding a psychological condition, particularly with respect to ferreting out axis 2 versus axis 1. We talked about third-party information. And now let's talk about access to records. Now, yes, Victoria.
Can you say an average or a range amount of time that a typical, if there was one, fit for duty evaluation, start to finish with all this stuff takes, with all your research, not just your interview, your research and all the people you have to contact?
The question is, how long does it take to do a fitness for duty evaluation on average, or a range?
Whatever way you wanna do it.
Sure. It can range from person comes into my office,
Yeah, he says,
person says, I'm absolutely unfit for duty. Are you kidding me? I can barely eat my Cheerios, man. I mean, he's crying right now, he's uncontrolled. I don't even know why I'm here. I admit I'm unfit for duty. Okay, that happens that morning. I pick up the phone, I call them, the evaluation's done in probably 3 or 4 hours.
but I mean including all the pre-stuff you do with the agency.
Well, that could have been, I mean, I might have had, you know, I do paperwork on Friday typically. If it was an emergency, I might have cleared my Friday morning and done the evaluation. You know, I sometimes screw my life up by doing that kind of thing.
I guess
you know.
I'm not asking how much time you spend with the guy.
No, what I'm trying to tell you is that that initial phone call could have come in on Thursday afternoon. I might have seen him on Friday, and we might be done Friday. So if I have the room in my schedule, or I had a cancellation the day before, and I get this person in, I could be done from one day to the next. And my report may be a very quick report. So it could be very, very quick. On the other hand, if I have lots of records, if this is a second or third opinion, this is already in litigation, it may be from beginning to end 3 months before it's all done. So it's a range.
Wait a minute, I'm asking the time you put in, not from when.
How about your hours?
You want to know how many hours
How
I've been
many
in
hours do you
evaluation?
bill?
No, not how many hours you do.
David, you're kind of.
It's an interrogation, Dave.
Whether you do it over a month or a week, how many hours do you
No, I
put in?
got that. I got your question. I'm just trying to decide whether to answer it. No.
Do you want an attorney?
No, no, it ranges from maybe 4 to 25, 25 hours. Yeah, 25 hours.
Just a question.
But that's the first way. You know, then if we get into litigation, then it
No,
could be
I
more.
mean first
Yeah,
way.
yeah.
Quick question.
Yes.
Document sources, third party and collateral interviews need consent outside of the department from employee.
Correct.
Okay.
Correct. So you can't just start phoning employees. Yeah. The question is, do you make disclosure to the collateral sources about what you're doing and where that information is going to go? Absolutely. You have to disclose to the collateral sources how the information is going to be used and what purpose it is. And that's why you just can't start making these phone calls. You have to have permission either from the agency or from the employee.
Or both.
Or sometimes both. Exactly right. All right, so let's talk for a moment about Colon versus City of Newark. Here's a case where a New Jersey police officer was referred for fitness evaluation after a spousal abuse complaint and was then returned to duty. A year later, the officer got into an altercation with an inmate and a lawsuit followed. The employer never provided the psychologist, the examining psychologist in the second case, in the second referral, with the results of the first never provided the fitness for duty examiner with the results of the first pre-employment psychological examination. Pre-employment. They didn't provide him with it. That showed him to be, quote, a danger to the community.
Pre-employment? And he was hired?
And he was hired. It was not Oregon. This is Newark. It's not Newark, Oregon. Okay. And documents pertaining to previous internal affairs investigations and disciplinary actions. So there was a pattern of behavior. Some of you have said, well, in the agencies where you work, you could say this person's unqualified and they still might get hired anyway. Such was the case here. So what the court said was that the incomplete picture of the officer's history constituted a deliberate indifference on the part of the employer and was a moving force behind the assault on the plaintiff. This is why I will always look at the pre-employment psychological evaluation, and I will always ask for it whether I've done it or not. Because I'm not going to get caught in Collin versus Newark. You know, doctor, it was in your files downstairs and you didn't look at it? No, I didn't. I thought that might violate the employee's rights. How about the public's rights? This is a police officer, for God's sake. Right. That's Collin versus Newark. Thomas versus Corwin. This is an 8th Circuit case where the 8th Circuit Court affirmed the termination of a police officer employee who refused to provide their medical records to the fitness for duty examiner. Now, the request for records under the EEOC interpretation of the ADA cannot be broad. They have to be as appropriate to the referring issue and to the fact-specific case. They have to be narrowed in scope. So let me give you an example. I did a fitness for duty evaluation of a woman who alleged that she'd been raped by a fellow police officer. This complaint of hers had already been investigated criminally, and there was found to be no evidence to support her position. She told me that she is traumatized, and she didn't want to go back to work, and the employer was saying, you need to come back to work, and she's going, I can't, I'm traumatized, I have PTSD from this rape that I had. So she told me in the course of the examination that she had, on the day following the rape, gone to her gynecologist and had reported the rape. And I said, well, that'll be an interesting medical record to have. I want to be sure to see that. I'm sure he's probably commented a bit on her affect and on her condition. So I said, great. I need those records. She refused. She got fired. Got to provide them. It's a narrow scope of the examination. I cannot make a determination of her fitness absent that. And what happened was, they didn't fire her for lack of cooperation. They fired her for being presumed to be unfit for duty. You got to prove that you're fit. The presumption here is you're not. You've already said you're not able to come back to work. So you're unfit for duty. If you want to come back to work, you got to prove yourself fit for duty. So in Thomas versus Corwin, the 8th Circuit said, by refusing to provide the psychologist the opportunity to review her medical records and to discover the root of her stress and anxiety, she created a stalemate in which the Kansas City Police Department had little choice but to terminate, you know this case?
I don't.
But to terminate her rather than return her to the position from which her stress and anxiety originated. So in this particular case, and this is the ones that you should really watch for, she said, she got a letter from her psychologist saying that she had to be transferred from this particular position because it's creating all this stress and anxiety for her. She's being treated badly and blah, blah, blah. So she's off duty for a period of time while she's being treated. Then she says, I want to come back to work. And she has her psychologist say she's okay, she's ready to come back to work. Here's the deal, folks. That privilege has been waived. The privilege she had with her psychologist may very well have produced a firewall if you only found out about it during the medical examination. But an employee who says, I'm giving my doctor permission to communicate to you, I have a condition, I can't go to work, I can go to work, your privilege is now waived with respect to that one. You can't have it both ways in that you're using your treatment as evidence to support a position, and then as soon as the department says, okay, well, let's see the records underlying that, you go, no, 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 that's private. Hey, if it was private, then you shouldn't have breached it in the first place. You shouldn't have said anything about it in the first place. You can't use it to support your position, but only use it as far as you want to. The court went further in Thomas versus Corwin and said not only does the psychologist have the right to have it, The department has the right to review it themselves.
About medical record?
The medical record, the treatment record. Because you've already communicated to the department what your psychologist's position is. They have a right to see the underlying facts associated with that, because it's possible that your psychologist is simply advocating for you, and that there is in fact other details associated with that record that may show an inability to perform your duties safely and effectively. It's an employer's obligation, and the employer does not have to simply work through their medical expert. They can do so on their own. I don't know if that Eighth Circuit opinion would be held in every circuit, but I'm telling you, if you need access to those records, do it, get it. Now, if they refuse, let the employer deal with it. I would never provide an evaluation where I say, the person's refusing to provide records, but here's my opinion in the absence of those records. I'd say I can't make a determination yet. I don't have the records. Now, if I can make a determination without the records, I will be happy to do so. Sometimes it's just gilding the lily. It's additional information that's not particularly relevant. Yes, Ann?
Are you okay with a verbal from their psychiatrist?
I sometimes am
psychologist?
okay with, the question is, am I okay with a verbal from their treating healthcare provider? If I can be, I always try to be, Ann,
Yeah.
because I don't really want psychotherapy records. I believe that they're pretty sacred documents, but it depends on the facts of the case. If I think that I'm being lied to by an employee, if I think that I'm being lied to by a healthcare provider, if I think that they're hiding something that's relevant to the determination of fitness, I want to see the records. And I've not had a case where I've been compelled to reach a conclusion in the absence of it. The real sticky wicket comes when there is a difference of opinion between you and the healthcare provider on return to work. And I've had arbitration cases where the arbitrator has ruled that I am simply advocating for the agency, and the person's healthcare provider really knows her best, and I've had the reverse be true. One of the things that I have come to believe about forensic cases generally and fitness for duty cases specifically is I don't care. I really don't. It's not, when I say I don't care about the outcome. If the arbitrator decides they're going back to work, that's the employer's problem. It's not my case to win or lose. I'm just testifying as to what I saw, how I reached my decision, what I did. Whatever the outcome is what the outcome is. But it is very, very difficult to at times resist when the healthcare provider is saying, this person is ready, this person is fine to go back. And I'll tell you one case that I, to this day, regret. And this was a case involving a correctional officer who had an alcohol dependence problem. And I found him unfit for duty. He was untreated. He got treatment, but his treatment was rapid. 3 weeks, his healthcare provider, who's a certified substance abuse counselor, is saying that this person is ready to come back to work. I examine him. I disagree. He's still unfit for duty. They start raising holy heck about this guy. I mean, they're calling the department saying that his attorney's now involved, that he has now 3 healthcare providers all saying he's ready to go back to work, and I'm saying I really don't believe he is. Ultimately, I conceded, and he killed himself 3 weeks later. So, I've made a blunder, and I succumbed. This was shortly on the heels of an arbitrator's judgment that had ruled that the person should be allowed to go back to work because their treating healthcare provider knows them best, and I allowed myself to be influenced by that outcome, by that judgment. And I'm not going to do that again. It doesn't matter to me that their healthcare providers are advocating for them. If I really believe that they're not fit for duty, let it play out another way, but I'm not going to put my signature on it. Yeah.
I've had it the other way, where the healthcare provider is saying they can come back to work, but they can only work these hours or these days, and so they're trying to get them in a schedule rather than fully cleared to return to work.
It's
in a similar situation to the healthcare provider advocating. In California, PERS will put people off for stress disabilities, and then when they are, quote, cured, wants to get them off the books because they're paying a lot of money, then sends them back to the agency, and the agency says, we don't want this person back at all, and of course, who gets in the middle?
Yeah, we're talking about what happens then between California PERS, the retirement system, when they want to get them off the books and say they're now no longer disabled and they want to come back to work, and then you decide, but they're not fit for duty. At least California has a statutory provision that requires under the law that if you're on disability, you're found no longer disabled, you're now reevaluated to come back to work, and you're found unfit for duty, you must, under the law, go back on disability. You cannot drop in between. That's not true in Oregon. If you fall off disability, and you may not be disabled anymore under the terms of disability, but then you come to do a fitness for duty evaluation, and I or Mike or somebody else decides you may not be disabled, but you're also not fit for duty, then you're out. You don't have disability or a job. That can't happen in California. It shouldn't happen in Oregon.
Well, we've had it though where the person filed, they were found to be disabled, it was found to be permanent and stationary. They then applied for retirement and are declined. So
Yeah, that
if
might
they're
happen.
not disabled
Yeah,
to
disability and
decline, 'cause it's a
retirement are different
line.
systems.
And then they can't go back to work because they're being found disabled in terms of work, and then they're caught in between.
There was a question here?
I had a situation where I actually had a healthcare provider indicate that I was causing damage to their client by not returning them.
That was part of the claim with mine, that I was causing damage to them, yes.
Yeah, so ultimately, the employer has to decide who they wanna rely
Right.
with utilizing.
That's correct. Now, I will say, in the case of my suicided correctional officer, I did say in my report that the issue here is simply this, that when this guy is drinking, he is a direct threat to himself. Right now, the evidence is he's sober. I have very little confidence in the sustainability of his sobriety. So if you want to define fit for duty as being free of substances at this time and no evidence to suggest that he has been drinking in the past 6 weeks, then he's fit for duty. If you want to define it as a low risk for relapse, I don't think he's there. So my caveat was that still, I shouldn't have released him at all.
Well,
The outcome may have been the same day.
The outcome may have been the same, but it wouldn't have been on my back. Yes?
Do you have some thoughts about that time span? That's one of the biggest issues is, you see the guy unfit and then,
Yes.
well, how long till they get back?
The,
Well, I
the,
don't
que-
know,
the
I
question
can't
is,
do that.
with substance abuse or substance dependence, what kind of a time span? I think it depends upon the history, number one. I think it also is less about time span than it is about knowledge of relapse triggers, relapse management. We know from the literature that relapse planning and relapse management is really the difference between sobriety and relapse. But in addition to that, the ADA defines current use as use recent enough to suggest an ongoing pattern. Now, if a person has been in a controlled institutional treatment environment for 30 days, comes out, goes from the institution to my office for a fitness for duty evaluation, I have no knowledge of this person's ability to sustain sobriety in a non-controlled environment. I'm not going to find him fit for duty. It's a very good question, though, as to how much time should go on before I do. Yes, Joe?
I think current medical thinking for substance and alcohol abuse is 1 year rehabilitation.
Yeah, but you're not, I mean, if you say this person has to be alcohol-free for 1 year before they go back to work, boy, that's going to be a very prohibitive position. But I understand
How do you measure it?
yes, it's how you measure it.
Do you have an example of what you then say to the agency who's saying, all right, but then when do we send him back? When do we send him back to see you if he's not fit now? 6 months, 3 months, 2 months?
Well, I think what we have to ask is, what does the literature tell us are the elements that need to be in place for successful sobriety management? And you know, they include a psychoeducational component. They include a mechanism for an adequate understanding of relapse triggers. It doesn't necessarily have to happen in AA. That's one method for it, but there could be other ways in which that occurs. But if none of those things have happened, if there's no aftercare at all, if there's no understanding of what are relapse triggers, or whatever language they may use for them, then I don't think they even meet the essential tenets of successful recovery that the literature informs us about. Okay, so this idea that that you require the employee, or that you can't get access to records, is simply not true. It is true that the records must be authorized. The release of those records must be authorized by the examinee, but the department can compel them to do so. I don't think I've included in my documents a copy of the informed consent, excuse me, of the release, in large part because I rarely use it. What I prefer to do is to tell the employee, these are the records that I need. I'll write them out, type them out, and you need to authorize your healthcare provider to get those to me. I'll also copy the employer so that they know what they're obligated to do. And I indicate as soon as they get those records, I'll complete the evaluation. The reason being is that if they complete the release form in my office, 9 times out of 10, the healthcare provider has their own form that they want them to sign. And we're just back to square one and we wasted time. So I go, you know, don't worry about mine, get yours. However, when I do have my release form, I have the GINA notice in it. And that is the GINA Miranda, where you have to tell, GINA in their final rule tells you, you have to tell the medical provider, don't give me any family genetic information, which is defined as. Because in their notes, they're going to have about the whole history of the alcoholic mother and the alcoholic father and all that. You're not entitled to that. But because you're asking for records and you're an agent of the employer, you have to warn them to redact that information from the records. That's in the rule for GINA. Unlike HIPAA, the violations with GINA add up very quickly, very high, and there are no limits to it.